We are going to talk about 11 key considerations for the LGBT plus QIA community when it comes to estate planning. Estate planning documents everyone in the community needs, and they're going to say things like a trust, a healthcare directive, a durable power of attorney. Well, sure, yes, but those are for everyone, and they're not specific to the community. They're just documents that everybody 18 and over needs. So let's talk about some things that are hyper specific and important to members of the LGBT plus QIA community. Number one, confirmatory adoption. It is my understanding, and I'm not a family law attorney, that even if both parents are listed on a birth certificate, that many states do not recognize LGBTQIA plus parentage equality. So confirmatory adoption can be indicated, and we provide a referral for that. Second parent adoption. If the parents were not married at the time of birth, maybe a second parent adoption is needed, and we can provide a referral for that. Now, why are these things also really important from an estate planning perspective? The definition of child is important, and if you think about family members who live out of state, where your child might not be considered your child outside of California in your parents' estate plan in Alabama, Mississippi, a lot of those other states, really critical. Healthcare and incapacity documents, they need to be comprehensive and really address who's in charge and who gets to take care of you. LGBTQIA plus proficient and experienced healthcare providers. Every estate plan for the community should contain gender neutral or gender correct language. The use of dead names, it needs to be addressed. There are legal names on legal documents, and then there are people's names. So we really need to think about this, and we've worked with many clients to write side letters that say, we are so sorry about the use of this name, but it is your legal name, and the banks and the IRS and all these other people are going to need to see this. If you ever do legally change your name, we will revise our documents, and we are very sorry about this. Preventing recloseting. The Advanced Healthcare Directive and the Power of Attorney need to address the requirement that your agents find competent care for you so that you can live in dignity in your final days. Recognizing non-traditional families. We have worked with couples and thruples. Clients are looking into third parent adoption. How do we plan for a diverse family structure? How do we do this? Because not every family is comprised in the same way. Protecting your legacy, really allowing your estate plan to deny assets to people who did not support you. If you are infamous or famous, to an extent that when you pass, you might have a right of publicity, to make sure we're keeping that out of their hands. Access to clergy. Here in San Francisco, we have the wonderful Sisters of Perpetual Indulgence, and there are other more traditional churches that specifically cater to this community. And just, requiring your agent to source LGBTQIA plus competent providers when it comes to anybody who's going to be making decisions for you. Making sure that if they're hiring a financial advisor, that the financial advisor has experience and they understand the kind of financial pressures that you might be under, the discrimination you face, that you probably make less money. All of these things are really important because the entire team has to be on board. My name is Patricia DeFonte, and I hope that I am a good ally. I am the founder of DeFonte Law, where we practice estate planning with heart. We believe that Black trans women's rights are human rights, and if you do not believe this, please forget you ever saw my face. We work with clients all over California on Zoom. Learn more at estateplanningwithheart.com.